Hi, I'm Tammy Saltzman. I'm your host of Divorce Connection Network. Today we are here with attorney Steve Belson, who did his undergrad and his law degree in Michigan and then his LLM in taxation in Boston. He's been practicing in Florida estate planning for almost 30 years, and I am so glad to have him here so that we can welcome him to the show. Hi, Steve.
Hi, Tammy.
Hi, good to have you. Thanks for coming.
Great to be here.
Great.
Thank you.
Good. So, the purpose of our show is to provide relevant information if you're contemplating a divorce, and today we're going to ask Steve 3 tips to provide to anyone thinking about a divorce what they should think about with regard to their estate planning. So, Steve, what's your first tip?
Well, my first tip is to have a relationship with a divorce lawyer, because frequently what happens is I hear from divorce lawyers after the fact about their clients needing an estate plan.
Okay, so when you are contemplating a divorce, Steve's first tip is to find a good divorce lawyer and make sure you let your divorce lawyer know whether or not you do have a current estate plan or you are in need of an estate plan. So when a divorce lawyer calls you, are they calling you at the beginning of a divorce or after the divorce is over?
Unfortunately, typically after the divorce is over.
Okay. So you would recommend that before they even contemplate divorce, having a review of their current estate plan?
Absolutely. And the reason for that is that typically clients either have no documents or they have documents, but if in the event that a client were to die, the assets, if they have no documents, they would go under the Florida scheme, if you will, which gives everything to that divorcing spouse. And until that divorced spouse, as you know, until there's a divorce decree, doesn't matter if you're in the midst of a divorce proceeding, if you are not divorced and all your assets, you die, they're going to go to potentially to your ex-husband, ex-wife, and that may absolutely be not what you want.
Okay, so let's recap a little bit. So tip number 2 would be, if you're contemplating a divorce and you're separating and you are thinking about filing for divorce and you may have already retained an attorney, during the time between retaining the attorney and filing a petition, it could take 3 months, it could take 6 months, it could take 3 years before you actually get a final judgment stamped by a judge. During that time period, even though you're no longer married and in love with your spouse, legally you are still married. So if something were to happen to you, all your assets would fall under Florida statutes and give your spouse a portion of your assets, even though that may not be what you want. Is that correct?
That's absolutely correct. My recommendation would be...
Tell the audience. Yes.
For someone like Tammy, as a divorce lawyer, that she immediately get copies of the estate planning documents from her client at the time that they walk through her door, and get copies of those documents, get an updated inventory of assets, and also get a copy of insurance policies, annuity contracts, IRA beneficiary designations, qualified retirement plan designations, because all of these documents will direct where assets go in the event of a death. And if it occurs before that final divorce decree, it could be absolutely contrary to what you would want done.
Also, I would imagine, while we're thinking on this term, is that if there was a car accident and one spouse was hospitalized and unable to make medical decisions, you might have a child or a mom run to the hospital, but ultimately would that spouse still have authority to make ultimate decisions?
Unfortunately, potentially yes, depending on the documents that are in place. So the additional documents to the will, the trust, is also what are called advance directives. Healthcare surrogate, durable power of attorney, those should also be changed, directing to have the individual that you want other than your soon-to-be ex-spouse.
Right. When you're married, your spouse is usually your personal representative, your trustee, your power, the person that you're giving the power to make medical and financial decisions to. And when you separate, it took me 4 years before, everything was final. You may not want that person to be your power of attorney. And if you have documents that give them that authority, I think that is worse than having no documents whatsoever.
It could be. Very much could be. And in fact, that leads me to guardianship
Yes.
and minor children.
Okay, let's talk about that tip.
Typically, what will happen in a divorce proceeding is that unless the spouse is unfit, they're going to get the custody of the minor child.
Okay.
But I would believe that you would not want, or typically people do not want that ex-husband having control over the assets for that child. So even though let's pick on the husband.
Okay.
Even though the ex-husband is the one that will likely be the custodian or guardian of the minor child, you can separate who manages the child's assets. So trusts are important.
Right. I know that I had a trust set up once I separated, and it said that all of my assets will be managed by my brother for the benefit of my son, even though my son ultimately would go and live with my ex-husband as a first option for him. I did put in there that if anything should happen to my husband, where I would want my son to go, and now he's 13, so they have their own opinions about things.
Well, that's another reason why a trust is important, because in Florida, if you're 18, you're considered an adult and you're going to receive the assets. If you have a trust, you can structure and hold on to those assets for the benefit of your child beyond age 18.
Right. So you could say that, after 18, money could be used for college. And if they complete college, then they would get a portion, a lump sum. And then once they got married, they might have...
Right.
So you can set up different things for your children so that they wouldn't get all the money at once. So estate planning is pretty important in the whole realm of contemplating a divorce.
It's extraordinarily important because it could be catastrophic if someone dies before they change their documents, before they direct where their assets go. Not only are the wills and the trusts important, but there's the joint ownership. That property would go potentially to the person you don't want it to go to. Beneficiary designations, life insurance, annuity contracts. IRAs, those can be changed without the consent of the spouse. Now, it's qualified retirement plan assets like a 401k, a money purchase pension plan, those require the consent of the spouse, so you're likely not able to change that when you're in the midst of a divorce proceeding. But again, very, very important to address these assets right from the get-go and to develop a relationship. I tell the divorce lawyers they need to find competent estate planning counsel, and as a matter of their checklist, when they're meeting with the client, and typically these clients are more concerned about where's the money going to be coming from to meet their day-to-day living expenses, but you need to direct your assets in the event of that unfortunate...
Yes, we all have to make plans for ultimately those things. What if someone has purchased grave sites or plots and they no longer want to be with their spouse? What do you recommend that they do then?
That could be a real problem. You need to deal with that not only in your documents, but you need to deal with it up front in any kind of settlement agreement, because that's an asset. And that's something, the last thing I would think a divorcing spouse would want is their ex-husband right next to them for eternity.
Right. Well, these are some of the things that people need to think about when they're contemplating a divorce that they may not have thought about.
Right.
I know that some people come in a second marriage and they're very concerned about these things when they're getting married for a second time, and they're like, well, am I being buried with my first wife and we have this whole family plot, or am I going to be with my new spouse, and where's the new spouse? Is the new spouse with the old spouse? It could get very complicated.
Right. And something that's new under the law is called portability, which is an exemption from estate tax. This is for the larger estates, where the exemption, which is now basically for a husband and wife in excess of $10 million, and it used to be the exemption was a use it or lose it. Now it can be carried over and provide it to the surviving spouse.
Wow.
But that's something that really should go into a settlement agreement, and a lot of lawyers aren't even aware of it.
I'm so glad we had you on today. I think anyone contemplating a divorce should contact their own estate planner to review their documents. And if they don't have a good estate plan or they'd like to get a second opinion, Steve would be a great person to contact. So where does our audience reach you if they'd like to meet with you?
They can reach me at 561-613-4000, or they can email me at sbelson@belsonkarsh.com.
As always, we'll have Steve's contact information on our divorceconnectionnetwork.com website. Thanks for joining us.
Thank you.